I invite the Honorable Attorney General, Mr. Basil Williams, who will give his opening remarks. Please welcome him.
This afternoon, it is here that we have decided in Guyana to start a series of anti-corruption sensitization meeting. Right here, what I call the heartland. And you know that it is a very important aspect of the policy of this government that we protect the assets, state assets, which are your assets, the assets of the people and of the nation. And you know there's this conventional theory that there's an inverse relationship between corruption and poverty. The greater the corruption, the greater the poverty of the people. It follows because if they siphon off the assets of the people, then there's nothing for the government to spend on the people. And so it's very important, and our aim is to inform you, the members of the public, and major stakeholders, because you are all employees. And any government, certainly our government, must perforce take the relevant measures to stop the hemorrhaging of state assets through the unlawful conduct of public officials. The State Assets Recovery Act embodies the anti-corruption trust of the state of Guyana, and it is predicated on the United Nations Convention Against Corruption of 2003, which was ratified by the government of Guyana in April 2008. It uses a civil recovery process as against criminal and is intended to give effect to the non-conviction-based asset recovery recommendations contained in the convention. This act enables a state asset recovery agency, SARA, which has broadly as its primary function the civil recovery of state property, as I said, obtained through the unlawful conduct of public officials. Now, we have two other bills we wish to discuss with you. This State Asset Recovery Act, as you know, was assented to by the President and published in the official gazette, bringing it into operation on the 4th of May this year. But this act has to be buttressed by two more that we're proposing to lay in Parliament, but are right now in the form of bills. One is the Protected Disclosures, or what we call the Whistleblower Bill, and the other is the Witness Protection Bill, both of which are intended to buttress the State Asset Recovery, the provisions of the State Assets Recovery Act. The Protected Disclosures, or Whistleblower Bill, commonly known, as I said, aims to combat corruption and other wrongdoing by encouraging or facilitating persons to make disclosures of improper conduct. The Witness Protection Bill will give effect to the Caribbean Community's agreement establishing the Regional Justice Protection Program of 1999, which came into force in 2006. And it also provides the establishment of a program to protect certain witnesses and other persons. I trust that this will be an informative and productive seminar for all.
I would now like to invite Mr. Charles Fongafat, Senior Counsel, who will provide an overview of the State Asset Recovery Bill.
The State Assets Recovery Act 2017 is intended to give effect to the non-conviction-based asset recovery recommendations contained in the United Nations Convention Against Corruption 2003, which was ratified by the government of Guyana in April 2008. The Act introduces legislation to combat unlawful conduct and corrupt practices in relation to property and other assets owned by the state or in which the state has an interest. The primary function of the State Assets Recovery Agency is the civil recovery of state property obtained through the unlawful conduct of a public official or other person, or any benefit obtained in connection with that unlawful conduct by way of civil proceedings taken in the High Court or a civil recovery order. The granting of a civil recovery order vests in the state ownership of any property subject to the order. The State Assets Recovery Agency will have a director with responsibility for the effective management and execution of its functions. Civil recovery is a form of non-conviction based assets forfeiture, which allows for the recovery of civil proceedings before the High Court of property which is or represents property obtained through unlawful conduct. The proceedings are non-conviction based, therefore, the director cannot charge or prosecute persons. His only interest is investigating and instituting proceedings, ultimately leading to the recovery of the stolen assets. The proceedings are civil in nature, and the civil standard of proof, that is, the balance of probabilities, applies. The cause of action is against the property itself, and not against the person who holds or has an interest in the property. The person who holds the property, the subject of the intended recovery order, might not be the person who carried out the unlawful conduct. And a civil recovery order is not a conviction of a sentence or a sentence. SARA will nevertheless require cogent evidence to satisfy the court that property is the proceeds of unlawful conduct. To establish that property was obtained through unlawful conduct, it will not be necessary to prove the commission of a particular criminal offense by a particular person on a particular occasion. It will be sufficient to prove that the property was obtained through unlawful conduct.
Our next presenter is Ms. Renetta Sargent, who will present an overview of the protected disclosures or the whistleblower bill. Please welcome Ms. Sargent.
In accordance with the government's anti-corruption regime, the Protected Disclosures Bill 2017 comes on the heels of the State Assets Recovery Act and will now place the power to fight corruption in the people's hands. The structure of the bill bears the imprimatur of our Attorney General and Minister of Legal Affairs and is a manifestation of his conceptualization as another anti-corruption bill which is in consonance with the Inter-American Convention signed by Guyana on the 29th of March 1996 and ratified on the 15th of February 2001. Article 3.8 of that convention states that state parties agree to consider the applicability of measures within their own institutional systems to create, maintain, and strengthen systems for protecting public servants and private citizens who, in good faith, report acts of corruption, including protection of their identities in accordance with their constitutions and the basic principles of their domestic legal systems. The bill was drafted in an effort to combat corruption and other wrongdoings by encouraging and facilitating disclosures of improper conduct in the public and private sectors, to protect persons making those disclosures from detrimental action, and to establish the Protected Disclosures Commission to receive, investigate, or otherwise deal with disclosures of improper conduct. The bill provides for the Act to apply to any disclosure made after the coming into operation of the Act where the improper conduct to which the disclosure relates occurred 12 years immediately before the coming into operation of the Act, or occurs after the coming into operation of the Act. Improper conduct, as defined in the bill, includes conduct that amounts to a criminal offense, failure to carry out a legal obligation, conduct that is likely to result in a miscarriage of justice, and that is likely to threaten the health or safety of a person or the environment, or conduct that tends to show gross mismanagement, impropriety, or misconduct in the carrying out of any activity involving the use of public funds or resources of the employer. The application provision may give rise to the concern that the Act is retrospective. However, be assured that the unlawful conduct defined in the bill relates to laws that are already in existence, and the legal consequences and rules applicable to that conduct will remain the same, making a disclosure of unlawful conduct that occurred before the coming into operation of the Act a permissive retrospectivity and will not conflict with Article 1444 of the Constitution because the conduct would have constituted an offense at the time it took place. The body responsible for receiving, investigating, and otherwise dealing with disclosures shall be known as the Protected Disclosures Commission and shall be a body corporate. In an effort to establish an impartial, inclusive, and suitably qualified commission, the bill provides for the appointment of the members of the commission, other than the chairperson, to be chosen from nominees, one from each of the following organizations, and to be elected by the National Assembly before being appointed by the Minister of Legal Affairs. The nominees are from the Integrity Commission, the Private Sector Commission, the Guyana Bar Association, the Institute of Chartered Accountants, Guyana Human Rights Association, the Guyana Trade Unions Congress, and the Police Association, being a retired police officer who was not below the rank of inspector. The bill, which provides a one-tier procedure for the making of disclosures to one body, enhances the protection of the person making disclosures. This procedure is unique to Guyana only and is superior to other systems of other jurisdictions. Its main focus is on protection of the person making the disclosure and the protection of the disclosures made. Other jurisdictions provide a three-tier system consisting of an internal procedure and a double-tier external procedure for making disclosures. At this juncture, it is apposite to note that another unique feature of the bill is that it provides for disclosures of improper conduct in both the public and private sectors, while most jurisdictions with whistleblower legislation provide for public sector only, with the exception of Malaysia. A highlight of the bill is that it provides for a wider group of persons who may make disclosures and of whom disclosures may be made. This is not so for other jurisdictions. Persons who may make disclosures of improper conduct are an employee, where the improper conduct is that of his employer or another employee of that employer; a person not being an employee, where the improper conduct is that of a member of the National Assembly, the Speaker of the National Assembly, a government official, or any other person with whom he dealt, is dealing, or is likely to deal with; an authorized person, where a person qualified to make the disclosure is afraid to make the disclosure and authorizes any other person to do so. In this bill, the definition of employee and employer have also been made wider to include a volunteer and an independent contractor and those that allow them to assist in their business with or without remuneration. A disclosure may be made in person, orally, or in writing, and signed on delivery by the person making the disclosure, or anonymously to the Commission by calling the Commission's hotline telephone numbers, or delivered by ordinary mail or by electronic messaging or mail. The provision for anonymous disclosures and disclosures by electronic mail or electronic messaging is a significant feature of this bill. For example, though India has provision for electronic mail, the identity of the persons making disclosures have to be given and proven not to be false, while the legislation of the United Kingdom, India, and Jamaica have no provision for anonymous disclosures. Malta's legislation has provisions for anonymous disclosure with no option for it to be protected. In contrast, you may observe that anonymous disclosures under our bill are strengthened by the option to subsequently disclose in person to the Commission at a mutually agreed date, time, and place, and receives protection. The bill also provides for special disclosures of improper conduct in relation to a matter that would prejudice national security, defense, or international relations to be made to the President, the Minister of Legal Affairs, or the Minister responsible for public security. The President and the Ministers shall determine the procedure for these disclosures.
Our next presenter is Ms. Joanne Bond, and she'll provide an overview of the Witness Protection Bill.
I just have to simplify the Witness Protection Bill for you, and hopefully by the end you'll understand what witness protection is all about. The bill gives effect to the CARICOM Agreement establishing the Regional Justice Protection Program 1999, which came into force in 2006. Already, the Bahamas, Jamaica, and Trinidad and Tobago have already enacted legislation to protect witnesses and other persons. The United Nations Convention Against Transnational Organized Crime and its protocol, and the United Nations Convention Against Corruption call upon state parties to introduce appropriate measures to prevent witness intimidation, coercion, corruption, or bodily injury. So this bill seeks to implement all of that, and it's a way for Guyana to show its international commitment. Now, what is witness protection? Witness protection is protection of a threatened witness involved in the justice system, including defendants and other persons, before, during, and after a trial, usually by the police. While a witness may only require protection until the conclusion of a trial, some witnesses are provided with a new identity and may live out the rest of their lives under government protection. And it's important to note that participation is voluntary, so no one is going to force you into witness protection. Now, why is witness protection important? Witnesses play a crucial role in the administration of justice. The cooperation of victims and witnesses is crucial to achieving successful prosecutions of criminal offenders and dismantling organized criminal groups. And it's important to know that witnesses are the cornerstone of any successful prosecution and investigation. If you don't have witnesses, then the case will not go anywhere. However, one of the challenges faced by the criminal justice system is investigation and prosecution of crime is obtaining such cooperation. Persons don't want to come forward. Victims and witnesses may be reluctant to give information and evidence because of perceived or actual intimidation or threats against themselves or members of their family. Now, who can be protected? Now, Clause 2 of the Witness Protection Bill contains definitions of key terms in the bill. And one of those key terms is participation, participants. And participants are witnesses, jurors, judicial officers, legal officers, law enforcement personnel, associates of such person, including familial associates. So it's not only limited to witnesses, but also to persons who are involved in the trial and who also need an investigation. So even judges, jurors, and also your family and your close associates. Cases to be considered for protection. The Witness Protection Program is designed to provide participants with protection or assistance or both, in both civil as well as criminal matters, in respect of offenses set out in the first schedule. Now, these offenses include murder, manslaughter, treason, robbery, any sexual offense, any domestic violence offense, trafficking in persons, offenses under the Anti-Money Laundering and Countering the Financing of Terrorism Act, as well as the Terrorist-Related Activities Act. So it's a whole list of offenses that can be considered for protection. Now let us look at the functions of the Administrative Center. I'm not going to list all. So the center has the sole responsibility for the management of the program. The center collaborates with approved authorities. And these approved authorities are the President, the Attorney General, the Director of Public Prosecution, and the Commissioner of Police. And the center also determines the level and duration of protection or assistance. And the center will determine the level based on collaboration with the DPP as well as the Attorney General. Another important function of this center that I wish to point you to is that the center liaises with the appropriate authorities of other CARICOM jurisdictions as well as non-CARICOM jurisdiction, because witness protection would not only be confined to Guyana, but also we could liaise with other witness protection programs in the Caribbean as well as throughout the world. We will now look at the functions of the investigative agency. Now, it is envisioned that this function will be provided by the police. However, the minister may determine that any other person can provide this function. And as the name suggests, the investigative agency conduct investigations, and they would submit their findings to the center. The agency will also prepare an assessment of the application, a threat assessment, and a risk assessment. Now, I'm going to briefly explain to you a threat assessment and the risk assessment. Now, these two assessments are very important to determine whether or not protection will be afforded. The threat assessment seeks to look to see what threat exists, if any at all. And they will consider factors like where is the threat coming from, whether it's a person or a group. Because, of course, if one person is threatening you, it's different from if it's a group of persons. They will also look at the capacity of the person or the group to actually carry out the threat. And it will also look at whether or not the person has the necessary resources to carry out the threat. Now, the risk assessment is there to examine the chances of the threat actually occurring. And so both of these assessments will help the agency to tailor the witness protection to the participant. So the witness protection that I would receive would be different from the one that you would receive, depending on the threat and the risk that exists. We will now look at the functions of the protective agency. Now, this function is also performed by the police force, or as I said earlier, the minister may appoint any other person to perform this function. The protective agency would submit a report to the center on the suitability of a prospective applicant for entry into the program. They will also interview the prospective applicant, and they will examine the threat and risk assessment submitted to the center. And they will also protect the participants and person accorded provisionary entry. And they also relocate participants. So they're the group of people that's really going to protect you. They may accompany you to court. You may have a security at your home, or they may be the persons that actually relocate you, put you in a safe house, or to transport you to another jurisdiction and help you settle in. Now, entry into the program. The center shall determine the participants in the program. So like I stated earlier, it is the centers who has the sole responsibility for carrying out the witness protection program. So they ultimately determine who will be a part of the program. And a prospective applicant shall apply to the center for entry into the program. However, when it comes to criminal matter, the DPP will make that application. Now, of course, it's important to look at the criteria for admission because, of course, everyone would not qualify. There are certain criteria that you must meet. So this criteria serves as a gatekeeping function. It ensures protection or assistance to participants who warrant protection or assistance. In deciding whether to include a prospective participant in the program, the center will have regard to the following: any criminal record of the prospective participant, the importance of the evidence or statement. Now, this is very important because if the evidence and statement is not material, then they would have no need for you in being a witness. The nature of the perceived danger to the prospective participant, and this is where the threat assessment and risk assessment will come in, because if there's really no danger to you, then there's no need for you to be a part of the program. The expected duration of the protection or assistance to be provided.
Well, I'm particularly pleased that the Attorney General and his team would have taken the opportunity to come and to simplify it. Ever so often, bills are passed, policies are made, and ever so often, it is not presented in a way, and the general public is not given an opportunity. I know there's structures, there's places you could access it, like the Library at Parliament, and it's in newspaper and a lot of times. But I'm particularly pleased that the model of reaching stakeholders, the model of engaging stakeholders, and really allowing for that simplified version of it to be presented. I'm particularly pleased that this was considered, and the program was nice. Even though it's a bill and it's a law, it was not long and boring. They found a nice way to package it, and I think it's a great move, and I'm pleased to see that the engagement have occurred.
Today's seminar was informative as it relates to the implementation of the SARA Act. And persons don't normally read the newspapers and become afraid with what is actually going on. So Ministry of Legal Affairs coming into the region and informing us about what are the plans of SARA and the bill that is being passed. I think it was passed. It promotes awareness for us as citizens of Guyana. And I hope that it just not apply to region number 10, but this outreach or seminar as it was today can be meted out to other regions as well.
Well, I believe the seminar is timely, it's very important, and judging from the amount of questions being asked, Lindeners really needed some clarity, and Lindeners do welcome this initiative by the government of Guyana. We believe that there were so much wrongs done nationally and, within our country. And I believe that there are assets that needs to be recovered. Right here in Linden, we would have suffered a lot. And there are many things we're asking, where have they gone? And we cannot provide any answer. All we know is that we were growing up, we know of this, we know of that, etc. But these things disappeared. And it was valid questions raised here today. And we would love for some kind of answers. We'd love for Sarah to be in action and that we can get answers, and two, that some of these assets that we believe are duly belong to Linden would be recovered. But speaking on a wider scale, I believe that this is good for Guyana. It shows that government is against corruption, and it shows that government is serious about corruption. So this is not talks. I believe this is walking the walk, and I commend the government for staying true to its word and looking seriously about development. I believe if we can weed out corruption, which is something very difficult to fully eradicate, but if you can minimize corruption, I believe the country will realize much growth. I believe also that we will see the true potential of our country.